Good evening. I, I, if I couldn't have looked any more freakish before, I figured out a way to look even worse. But I'm going to. It's Saturday night. It's time to party. And if you're me, you don't do that. So I thought I would go ahead and record a lecture about the law. Obviously, it's something that I've been passionate about my whole adult life, and I feel it's under threat. And so I want to give just a very broad stroke to the topic, and well, hopefully it won't be too boring. But when we think about the law, we're thinking about principles, concepts, as well as real life regulations and laws that guide and control the interactions of all people within a society and are enforced in one way or another by government. And when I say one way or another, sometimes we think of criminal law. I mean, okay, the state versus Joe, that seems clear enough, but the state is responsible for and applies civil law as well. So everything that is applicable to every member of society, whether it's an action by the government against you in a criminal case or your action against a negligent driver because you were injured in an accident. It's all governed by, but really in our case, it's governed by the Constitution ultimately. All of the separation of powers, the methods by which laws are passed, by which they're enforced, are all based on the government. So I'm going to talk about 5 basic types of law that have historically and continue to currently be the law in the United States. And those are 1, the common law, 2, equity, 3, statutory, 4, constitutional, and 5, administrative. So what do we mean by common law? Well, common law is also called judge-made law and is a set of rules that have been created by judges over time in the course of rendering decisions on court cases. These laws are based on precedent, that is, a case that sets up a new rule or application of a rule to a particular fact set. Once established by courts, the same rule may be applied over and over again. Once firmly established within a jurisdiction, the legal tradition known as stare decisis states that a rule should continue until there is a very good reason for it to change. A Supreme Court is the only court that can make such a change. Stare decisis requires that courts below the level of the Supreme Court apply existing precedents to cases involving similar facts, thus making the law stable and predictable. over time. Changes are the exception rather than the rule, and are made only if there's no existing rule, and that still happens even today. That there's still something that hasn't been decided, particularly in a state court jurisdiction. Now, suits at common law, which would have been at the time of the very beginning of the country and going back hundreds and hundreds of years before that in England, grew more and more technical over time. So the second type of law, or equity law, was created by the king to try to provide a remedy when harm had not occurred or could be stopped at the current time. So equity was designed to prevent a harmful act, if possible, or at least stop a harmful act quickly and not let it grow to fruition, while suits at law were left to things more in line with money damages. So under equity, a party could obtain a court order, sometimes an injunction to stop something from happening, sometimes through a writ of mandamus to order a public official to do or not do something that's happening. Injunctions are still very much sought after today in lots of different contexts, discrimination cases, environmental cases, and suits based on contract and tort are generally seen as at law and not in equity. Another type of law is statutory law, and then we're all familiar with that because statutes are what legislatures pass, whether it's the state, a county, a city, or the federal government. They go through the legislative process, and if they do so, it's based on representative ideas, and if those representatives establish a rule, then that rule is to be enforced by the court system of the state or by the federal government. Sometimes treaties, which are international agreements between countries to affect something like trade, can be enforced in federal court in the United States. Sometimes foreign law pertains to international law or law between countries or citizens or corporations of different countries. Domestic law pertains to the law within the country. Another type of law is constitutional law. As we know, going back to Marbury versus Madison in 1803, the United States Supreme Court said that the judicial branch was the unique branch that should be involved in deciding issues of interpretation under the Constitution, and they continue that work today. Now that also applies to states. The state Supreme Court does the same thing with the state constitution. The last type of law is administrative law. And when we looked at bureaucracy in the last chapter, we looked at regulatory agencies. And I said that one of the things that regulatory agencies did was provide an enforcement mechanism with specialized administrative law judges. The system sets up all the court rules and the means of interpretation. The Administrative Procedures Act, whether federal or state, sets out how rules are created, and general principles of legal interpretation are used by those administrative courts to decide issues of agencies. Let me talk about criminal law and civil law. Criminal law involves a claim by the government against an individual, which could include a corporation, for violating a code. The key thing is, if we're talking about criminal law, the code that is violated prescribes penalties of money or incarceration. These, of course, are only brought by the government. Usually, it's the state of Kansas versus Joe, and the state of Kansas is represented by either somebody in the Attorney General's office, or usually what we see local is the county attorney. If you're in a larger city, they'll have their own system, and it's usually referred to as a district attorney is a common term for that. So the state is a party to the case. The state represents all of us bringing this action against an individual for the violation of the criminal code. And it can involve either money or incarceration. And the person that the charge is brought against is called the defendant. Now, crime is generally classified as either a felony or a misdemeanor. And the difference is based on the amount of time one could be incarcerated. So a misdemeanor is an offense that would allow incarceration only up to 1 year. A felony is a conviction that would allow incarceration for 1 year or more. Of course, felonies are obviously the more egregious violations of societal laws. Now, civil law deals with disputes between individuals, or individuals and corporations, or corporations versus corporations. It's a breach of contract. It's a negligence action. Could be libel or slander. So, could be a slip and fall case. Somebody falls in a store. They slip on a grape and fall in a store. Don't laugh. I made my living on these types of cases. The party bringing the action is called the plaintiff, and the other party defending the action is called the defendant. Most everything today is run by insurance companies, actually. Even in some disputes between corporations, big disputes, insurance companies really control the shots. If you have a car and car insurance, then your insurance company has a duty to provide you with an attorney. That attorney will represent you and the interest of the insurance company if a lawsuit is brought against you for your operation of a motor vehicle. That's actually the kind of law that I did. I represented insurance companies and the insureds of insurance companies in premises cases, automobile cases, construction cases, death cases, workers' compensation, you name it. Insurance covers about everything. And the insurance company controls the lawsuit pretty much anymore because they have the money to pay out. They're responsible to pay out up to the limits of your insurance policy. And they can do that any way they want to. They can pay out the maximum, or they can take it all the way to trial. Whatever they think is the way it's going to play out. Okay, so let's talk about we always refer to the American system as an adversarial system, and it certainly is. It's an adversarial system because it's based on the assumption that truth will emerge from a clash of opposing interests. Clash of opposing interests. That includes either criminal or civil cases. In the United States, the attorney is considered to have no responsibility other than the client. Now, that not to say they do whatever they want, and aside from movies and television, it's not as bad as what it's projected to be. But for example, in England, the lawyer's responsibility is considered to the society primarily, and secondarily to the client. And that makes a big difference in how you look at things and how you try to answer ethical dilemmas that arise throughout your practice. So let me just mention the role of the courts. Obviously, courts are there to enforce the rules, and there are really three types of rules that a court enforces. One is procedural. In other words, did you file the action within the amount of time allowed? Did you have a discovery conference within the time period that you're supposed to do that? The second thing would be evidence. If there's a hearing of some type in which evidence is taken, it could be documentary, or it could be witnesses, or of course a trial, either a trial to the court itself or by a jury. The judge interprets the rules of evidence. For example, is hearsay allowed? I know you think hearsay is not allowed, but there are like 26 exceptions to the hearsay rule, so it's up to the judge to decide on all that evidentiary stuff. And then the third is to apply the common law rules. What is a contract? What is a tort? And what is negligence, and how's it defined, and all that kind of thing. Applying the law to the facts. Courts do not issue advisory opinions. This is true whether it is a state court or a federal court. You don't file a lawsuit and say, well, if Joe does such and so, I think that is negligence, and I think I might incur X number of dollars in damage, and judge, please declare these potential acts of Joe to be negligence. Courts will not do that. Courts only are involved in what is referred to as actual cases in controversy. Somebody has to really have something at stake. They have to have really lost something or will lose something. It's not a what if situation at all, and that's important to keep in mind. So the judge then is the presiding officer over the trial and is the ultimate decision maker on the law. What is the law? What law will be used? How the law will be worded? You have jury instructions at the end of the case that are written out statements of law, and the judge has to give final approval to those, although they're usually drawn up by the lawyers and are based on pattern instructions by each state's bar association. Same on the federal level, but there is a mechanism to again, the goal is uniformity, and so we want the jury instructions to be uniform as well. You don't want negligence defined Monday in one court a certain way, and on Wednesday the definition of negligence changes to something else. So we rely on the judge to make sure that those things are correct. Very, very rarely can you interrupt a trial with some type of an appeal. Extraordinarily uncommon to do something like that. In the criminal cases, the judge generally always makes the decision on punishment. If a person is found guilty, they go through a process of evaluation by the court system, and recommendations are given to the judge by investigators, and then both the state and the defendant can make recommendations with regards to a sentence. Judges also, if a civil case is tried to the court, then the court does have to find issues of fact. So either, if there's no jury, then the judge does have to have that role as well. If we were together, I'd draw a little diagram on the board that would emphasize to you the nature of the dual court system we have in the country. The dual court system is the state system and the federal system. When back at the beginning of the semester, we talked about federalism, the distinction between the federal or national government and the individual state governments. That difference, it also extends to the court systems. There is a federal court system which is entirely separate and apart from the court system that is in each state. Everybody has, the basic trial judge level and an appellate level. Some states you would go from a trial court directly to the Supreme Court. It's fairly typical, though, for states to have a trial court and a court of appeals and a Supreme Court, just like the federal government has the trial court, the Circuit Court of Appeals, and the federal Supreme Court. Every court has certain power to determine the resolution of disputes. This power is vested by either the Constitution or the state or federal legislatures, and it's referred to as jurisdiction. Every court has its own jurisdiction. For example, federal courts have a bankruptcy court. The Constitution says that Congress has the power over bankruptcy, so the court system at the federal level takes care of bankruptcy. You do not file a bankruptcy action in state court, in any state. That is solely the function of the federal court. Other actions, you have a car accident out at Walmart and there's a lawsuit. You don't bring that in federal court. That is in state court. Only very, very specific times could you bring an action in federal court. What a court can hear at the trial court level is called original jurisdiction, and then you have the idea of appellate or review jurisdiction. So the actions of a trial judge can be reviewed. In cases that are tried by a jury, the finding of facts that the jury makes cannot be generally appealed or reviewed. They're accepted as the jury finds it. The only issue on appeal is a question of law, application of a statute or an evidentiary decision, something of that type. Now, on the federal level, the U.S. Supreme Court has both original and appellate jurisdiction. The Constitution sets out specifically what the original jurisdiction of the court is. For example, disputes involving ambassadors, foreign governments, that sort of thing. Disputes between states. The state of Kansas and the state of Colorado and the state of Nebraska. Everybody that has anything to do with what is or becomes the Colorado River is constantly in the Supreme Court bitching at each other for one reason or another. So those contests between states are handled directly by the Supreme Court. Of course, they have appellate jurisdiction. They hear cases either from state Supreme Court or a Circuit Court of Appeals to review and determine the constitutionality of a particular law or action by government. Couple things about state courts that are in the Constitution that represented important elements for the founders, and one of those is the doctrine of full faith and credit. If you have a lawsuit in Kansas, and let's say it goes all the way through a jury trial, and the plaintiff wins $10, then the defendant turns around and leaves the state and moves to Wisconsin. There's a procedure that you go through that allows you to take your Kansas judgment, file it in a court in Wisconsin, obtain service on the defendant, and then have that judgment enforced. Wisconsin doesn't have a choice. As long as the laws in Kansas were followed and the judgment was properly obtained, then it can be enforced in Wisconsin. It can be enforced anywhere you can find the defendant or find the assets, which is the real thing you're trying to do. So full faith and credit is part of the Constitution. Another thing that comes up sometimes is what happens when the law of two different states is different. You're in a lawsuit in Kansas, but the law, let's say the location where the contract was breached or where the tort occurred is California. And say the law of California is different than the law of Kansas in regards to interpreting a contract a certain way. Well, the normal rule of interpretation is where the contract was entered is where you base the law on. So if the contract, let's say the contract was entered in California, okay, people actually met, negotiated, decided on a contract, signed a contract, but they were both from Kansas. That could happen all the time in business. So they're back here in Kansas, somebody screws up, somebody sues somebody. Now what law do you apply? Do you apply the law of Kansas? That's where you're at. Or do you apply the law of California? So that this is called a conflict of laws if the laws diverge, between the two states. So that's an interesting area sometimes that comes up. Now, let me talk a little bit about federal courts. There are two types of federal courts. One, and I mentioned this in regards to the regulatory commissions in the chapter on bureaucracy. One type of court is found in Article 1. Article 1 deals with Congress. Congress has the authority to set up courts of lesser jurisdiction or significance than the Supreme Court, if they so need, and those administrative courts are part of the federal system. The other type of court is a law court. That is in Article 3. Article 3 deals with the Supreme Court, with the judiciary branch. Courts set up under the Supreme Court or involving the Supreme Court are called constitutional courts. So they're set up under Article 3. So you've got courts that are in a direct line to the Supreme Court, and then you've got courts that are on these various administrative agencies, and there are routes of appeal that generally follow the same basic format, but the constitutional basis of those courts is different. There are something like 89 federal district courts within the United States, and that would include the District of Columbia and commonwealths and territories of the United States. They handle both civil and criminal cases. The judges are picked by the president and approved by the Senate. Specifically, the Senate Judiciary Committee holds hearings, and then the Senate votes. There, I think, are 13 courts of appeal or circuit courts within the federal system. There are also some specialty courts, like the tax court, the international trade court, that, of course, are very limited in their jurisdiction. So let me then talk a little bit about the United States Supreme Court. Naturally, the first thing you think of, rightly so, with the Supreme Court is that it's the final interpreter of the United States Constitution. However, they also have the authority over state law as well. So if an issue within a state is brought up and somebody says, well, that violates the federal Fourth Amendment, then that case can be heard by the Supreme Court as well. Now, almost every case the court hears is going to be, first of all, appellate jurisdiction. Original jurisdiction cases are a very small number. And the appellate cases, nobody has a right to be heard in the Supreme Court. The Supreme Court has to agree to hear your case. You go through a process by which you seek what is called a writ of certiorari. A writ of certiorari is an order from the Supreme Court to a lower court, like a Circuit Court of Appeals or a state Supreme Court, to send its record on a case to the Supreme Court for review. At least 4 of the justices have to agree to hear a case before it can be heard. So just, one person can't run off and say, here, let's decide such and such a case. There has to be not a majority, but close to a majority, just to hear it. And of course, the cases are briefed. In other words, the lawyers write up a legal document explaining what the issue is or issues, and what the record on appeal looks like, and their argument for their position. Those briefs accumulate, and of course there are many lawyers within the Supreme Court other than the justices, and people are constantly reviewing and analyzing and reading all of that material in order to prepare the justices. Generally, there is an oral argument. Interestingly, the oral arguments are usually very short and are really intended to maybe answer questions that the justices have, not really give the lawyer any chance to just stand and argue a position. There are several different types of opinions that the court issues. Of course, we're familiar with the majority opinion. It has to be at least 5. The it sets out the rationale of the court for deciding the case in whatever way they do. It's possible if a judge agrees with the majority but feels that he reaches that decision based on a different legal reasoning, then they'll issue what's called a concurring opinion. Of course, a dissenting opinion is, I don't agree with the majority, and here's why. One of the real difficulties in the politicized nature of the Supreme Court, and this has been true for many years, not just now, but is not really having a strong majority deciding the case. There may be, and there usually are, several issues involved. What if, some people agree on one issue, but a different group agrees on issue number 2, and so on? What is that? Well, an opinion can be issued called a plurality opinion. And that means that a majority, 5 at least, support a particular judgment, but that judgment majority don't agree on the same rationale. So everybody's writing separate opinions, even though at least 5 of them agree on a particular outcome. The problem with this is you look to the law for predictability. If you have a decision by the Supreme Court that says X is the interpretation of a particular statute or the Constitution in a given situation, but nobody seems to be able to agree on why, you lose predictability, which is the only thing that you have as a lawyer to try to advise your client in, based on predictability. So, you can end up with very, very difficult matters of interpretation, and it's just not a real good situation. Now, the Chief Justice is not just the guy that sits in the middle of the court when they're in session. It's a very, very powerful position. The Chief Justice decides who will write the majority opinion. The Chief Justice might keep that to himself or might assign it to someone on the majority to write a decision. Naturally, the Chief Justice is the presiding officer when the court is in session. He calls the cases and takes care of keeping track of the lawyers. There are thousands and thousands and thousands of cases filed with the Supreme Court every year, and just a tiny number are heard by the court. So it's difficult to have a case reviewed by the Supreme Court. Very difficult. Always going to involve some type of constitutional question. Usually there's going to be a split among the circuits. In other words, the different results under the same general fact pattern develop within different parts of the country, and so the Supreme Court uh, sometimes brings several cases together that are on appeal and then decides the issue. As I said, federal judges are recommended by the president and approved by the Senate. There is a longstanding tradition called senatorial courtesy, which if the senior senator from the state is the same party as the president. So let's say that we need a judge in Kansas. Okay, Kansas, Republican state, Republican senators, whoever, and I don't even know who it is. Whoever's the longest, like Pat Roberts, I guess, still is. Senator, and so we need to have this judge. Normally, the president will give way to the opinion of the senior senator on who it should be. In general, you've seen a very liberal court at times. We talked about, when we talked about civil liberties and civil rights, we talked about the 1960s, extremely liberal, if I wouldn't say progressive, but liberal group of justices fashioned the federal constitution around the states when it came to the Bill of Rights, when it came to civil rights laws as well, under the 14th Amendment. Now, you know, it's quite the opposite. It's, in my view, repressive. It doesn't matter whether you, I mean, you're certainly not going to have to agree with that, but very conservative. It's, this is a topic that, you know, I'd love to be able to tell you all my stories, but that would make it would make the topic somehow even much more unbearable for you. So we won't go into that. But it was a great career, and it was a great career choice for me. I didn't even know what the hell I was getting into when I did it, but it turned out to be a great fit, and certainly forever grateful for all the years that I had practicing. This will, I don't think I'm going to do a PowerPoint on the Supreme Court. I have one. It really, I've covered some of it in this lecture. What I didn't cover is covered by the Wilson textbook, and remember the PowerPoint, all the PowerPoints on Wilson chapters are in the content section of Blackboard. So let me sign off then. It's been a great semester. I'm sorry the way it turned out at the end, but I hope that you have a little bit more understanding of the system, the importance of the system, how it reflects on your life every single day. And I hope every one of you, regardless of who you vote for, I hope you go out and vote in the next election and in every election, because it's critical. So have a good break, and we'll see what happens to all of us as the year goes along. But good luck to all of you. I hope you all do very well in your career goals. And I hope that you have great happiness in what you choose to do and who you choose to do it with. Bye-bye.